Today I am joined by Byron O'Connor, Donald Dinnie, Patrick Bracher, all directors, and Michael McCarthy, associates at Norton Rose Fulbright. And they are all co-authors of the latest volumes in the Big Read book series. These publications, Volume 25, Insurance Regulations in Africa, and Volume 26, Subrogation Demystified, are part of a free open access initiative to support legal and regulatory literacy across the insurance industry. We'll be unpacking what these volumes offer, why they matter, and how professionals across Africa and beyond can use them to navigate complex insurance landscapes. Welcome to all four of you. It's absolutely great to have you.
Thank you. Hello.
Thanks, Rianet.
So let's start. What inspired this big book series, and how do you decide on which topics to tackle when?
Thanks, Rianet. I hate to mention, because it's going to trigger Patrick, and you won't hear the end of it, is our financial institutions legal snapshot, which you and I think all of your viewers will be familiar with, and that predates by some years. Patrick will remind us of year of origin, is the Bedroom book series, which started in 2018. I say as an aside, I say the Big Red Book and not the Read Book, but as you will get, that's a play on the redness of the cover and read it as well, but that's a whole nother discussion. The Red Book started in 2018, but it was a deliberate decision to supplement with some more substantial content and be complementary to the financial institutions legal snapshot. As you know, that's a very quick look at topics and particularly judgments as they arise, and I think we had an appreciation both within the practice and with feedback from the market that there was a need for something more substantial in terms of legal topics for the industry as they came up, and that's the origin of it. If you see the collection of the books and how they've evolved, there's some standard annual publications, like we do review annually, retrospectively, relevant material insurance judgments for the preceding year. But what we have done, you'll also see, is then add in more specific substantive content regarding specific insurance issues, largely generated by our interaction with the market, and vice versa. As to, marine clients will say it'll be useful to have a quick handbook and guidance on ex-marine principles, or in this context, most recently, subrogation, which raises its head every now and again when one gets judgments which one may not agree with, but we thought needs and benefits from a refresher for the market, and has been well received.
Both volumes are freely available. Well, all of them are freely available. Why is open access important for the insurance industry, and who do you hope will benefit most? And I want to add onto my question to ask if those are print and digital. So
starting from the back, yes, both. We go to market digital, but always offer print copies for clients. And the latest volumes that have been communicated to the market, we've had a significant response from those in the industry, including clients who want hard copies, and provided that to them. I think it's an appreciation of the dearth of actual, some more academic kind of focused analysis of legal issues in the market. One sees often, not to disparage it, general fluff reviews or notes about particular issues, but without getting really to the meat of a particular topic. So this is intended to be halfway between, I suppose, a more superficial review of a particular issue, and not something that's too heavy from an academic point of view, which means people aren't going to read or be able to digest easily. But to make it accessible to all the role players in the insurance market. So it's not necessarily insurer focused, although certainly from our practice point of view, we are a market directed from that perspective, but assistance to intermediaries, loss adjusters, experts who might have a role in the industry, all of that. What it certainly isn't, and ashamedly isn't, it's not consumer orientated in the sense of
Yeah.
from that perspective. It is from a market perspective intended to be of assistance to the whole gamut of those role players in the market. So certainly what we would welcome is feedback from the market as to topics we haven't covered and they think might be of use to them. That's always useful. We're always kind of minded of you sit in there what we think are brilliant and useful ideas for the market from our perspective, which might not necessarily always be that welcome or useful for those sitting from a different perspective.
Yeah, so please, anyone who listens to this and wants some additional topics covered, that's great. Thanks. Thank you for that, Donald.
What we've done now, we talk about hard copies, is in a version we're coming out of New Year's. We have consolidated. We're now at 26 volumes, as you know. So to split equally, we've created books 1 and books 2 of it in hard copy, so you can use it to press your flowers, prop up your coffee tables, or actually to have easy at hand to flip through. If you're like me, I actually find it very useful to have there, and I know I often use it for a refresher in terms of a particular topic, because Volume 2, for example, deals with and reviews the general principles of rejection of claims, avoidance of policies, which includes pro forma wordings for those type of things. And it's a constant, easy resource for me. And I know many in the insurer component industry use it as a quick source of reference when they're dealing with claims and want some quick guidance.
Let's move on to volume 25, Insurance Regulation in Africa. Volume 25 covers 12 African countries. What were some of the most surprising regulatory differences or trends that you have uncovered?
Yeah, can I start there? Michael did a lot of the research and gathering all this information together around Africa, which is not easy for busy lawyers, but that we had a sort of a good extent of cooperation. What we found is that more and more people are going into Africa with insurance, and it's becoming an attractive market. And we looked to, if you look at the headings, you'll see that we chose certain headings so that they could be compared throughout jurisdictions.
Okay.
I started that publication years ago when it was still a print copy. It's become much easier now in the electronic age to source information and to check information. And also we have throughout Africa contacts in various jurisdictions. They're not necessarily partners of ours, but they're close relationships with some of them. Other ones, good relationships where we know where to go to get good advice. And that's how we chose those particular jurisdictions. I think the surprising thing, and if you want a surprise, is that how similar things are. You know, many of the jurisdictions are based on English insurance law. And even when you go to places like Angola or Mozambique, which didn't necessarily have a tradition of English insurance law, that the documents are similar. You can pick up a policy from anywhere in the world these days, and you'll find wording that I always say that goes back to the 18th century. You know, some of it hasn't changed. So it is familiar, but what we've done is examine the regulatory scope. So you get an idea up front of what is going on there, what those restrictions are, what the protections are, and what the capital and money requirements are. Michael, do you want to add something about policyholder protection?
Sure, thanks, Patrick. Just on the point of what was surprising, as Patrick mentioned, we've obviously got some exposure through a number of African jurisdictions, but it was interesting to see that some of the jurisdictions don't have as developed policyholder protection rules like South Africa does, outsourcing regulation, that sort of thing. A lot of it, as I said, we've dealt with in some of the jurisdictions. There's local ownership requirements, there's foreign direct investment requirements in some of them. And that's not surprising, but what was, to me at least, surprising is the lack of policyholder protection or specific policyholder protection rules in some of the jurisdictions.
Okay, very interesting. How can insurers or investors use this guide when considering cross operations or partnerships? But let's delve into that.
I think there are two things. One, you can get an immediate we use the word snapshot in our blog, but you get an immediate snapshot of what is in that jurisdiction when you're thinking of going there. And secondly, it gives you access to the basic information and then a contact with a firm that knows what they're doing in the insurance world.
Okay.
When you want to go and look in more detail in any one of those headings or anything else that relates to your direct investment in those countries, it's accessible. And, we can obviously add to it as well because of our particular tools for online research throughout Africa. So it's just a starting point, but it's a very useful starting point. So
Yeah.
you can look immediately, do I want to go there or don't I? And if I do, I can fetch information.
That is very valuable. What role do alliances and local legal networks play in compiling and updating this kind of comparative regulatory content?
Well, that's absolutely essential. As I said, to persuade a lawyer in Ghana or Kenya or Angola to send you a chapter in our book is not easy, but we've got the associations and the alliances that we can draw on. We know people there, we can phone them up personally and get input. And obviously they get a reciprocal advantage of appearing in the book and having their names, and when people are looking for expertise to go there. But Michael did a fantastic job just getting these people to all produce similar things at a similar time and getting it into publication.
Yeah.
Michael, anything to add?
Yeah, I would also just add it's quite important. For example, in Mozambique, all the base legislation is in Portuguese, so you obviously need your local counsel to give you, their chapter in English on what's going on there, and then it wouldn't be possible without the alliance partners. Getting that much law into a single document from a single location wouldn't be possible. So we're very, very appreciative of our alliance partners, and they were very helpful in getting the document together.
Volume 26, Subrogation Demystified. Subrogation is often misunderstood, and we know that. What are the most common misconceptions you aimed to clarify in volume 26? Byron or Patrick, who else going to take that one?
Yeah, so
Byron will shout, and Patrick probably won't be able to resist and comment as well.
Okay.
so talking about the sort of most common misconception, Rianet, I suppose it's just important to perhaps emphasize that, subrogation is a procedural right, and it really has two objectives at its foundation. And the first really is that the insurer doesn't end up being the party responsible for bearing the loss, and that loss ultimately ends up with the third party that would have caused it, but then also that the insured doesn't end up recovering double compensation. So it doesn't end up receiving compensation from both the insurer and the third party. So having said that, it's often stated that, an insurer steps into the shoes of its insured, and that's really a misnomer, because it's because it's a procedural right that is transferred. The insurer doesn't acquire the rights of the insured. It merely manages the process or controls the process of recovering from the third party. So perhaps this issue of the insurer recovering or acquiring the rights of the insured is one of the most common misconceptions.
I have to take Donald's invitation. I've been for years.
It wasn't an invitation, it was a warning.
A warning. And that phrase "step into the shoes" has just been used by judges, by lawyers, by textbooks, by everybody, and it creates, as Byron says, a complete misunderstanding, because it's not a cession or assignment or transfer of the rights to recover the amount. It's a transfer of the right to procedurally act on behalf of the insured in recovering the amount. And we did this. We first did a seminar, and then we did the big read book, if you like, because there was a judgment in the Western Cape which showed no understanding of the subrogation issues, and that's where it came from.
Okay. And I'm sure AI is confusing the matter even further for those who are using that wrongly. How does subrogation differ across sectors like construction, marine, and project insurance? And why is that important for insurers and brokers to understand? Because I'm sure there can be easily confusion there.
So from a legal perspective, and insofar as the legal principles are concerned, Rianet, there's not really a difference in the requirements and what subrogation entails. But from a practical perspective, in an insurance, in a construction insurance scenario, and in a marine insurance scenario, there, for instance, in construction, there might be different parties at play, and it often arises in that context whether an insurer has the ability to subrogate rights of the various parties that are involved in a construction insurance situation. For instance, you might have employers, contractors, and subcontractors, and there's often issues that arise from that perspective. And from the marine insurance side, similarly, there's potentially issues in relation to multidisciplinary legal principles that would apply, for instance, the English law and the South African law. But as I said, from a substantive law perspective, the principles don't really differ, but insurers should be aware of specific nuances that might be applied in the different relationships.
Yes, I think, Rianet, the other thing that needs to be highlighted that there are two types of subrogation. One is under the common law, and that differs when you go to marine, you go and look at a 1906 Marine Insurance Act, for instance. Their common law is slightly different, but the common law has limitations. So insurers have forever built in what we call a contractual subrogation, which says I can step into the shoes, if I can use that phrase again with Hannah that explained it, and I can take over the running of this action on your behalf, even if I haven't paid you out yet. And for instance, that's very important in marine insurance, where there are strict time limits for pursuing claims. You don't want to be investigating a claim for 2 years and find your time limits are run out, for instance. So we encourage insurers to look at their contractual subrogation clauses to see, A, that they cover what they're doing, and secondly, that if the insurer doesn't behave, that they pay the money back or have some consequence, so that subrogation works efficiently for the reasons that Byron gave. And just to illustrate with contract insurance, you know that construction insurance policies, they have a list of people who are insured under the policy, everyone from the employer down to the subcontractor. And you can't just assume that everybody has got a right of subrogation, or that they've waived a right of subrogation, that you can proceed against some and others. So each one has its nuances that you have to look at, and project insurance is the same, marine is the same. So it's not just stepping into the shoes and doing what you like. You've got to look at things.
And that's why people like you are there. You can read about it, but go to the lawyers with the knowledge to figure that out. What practical steps should insurers take to protect their subrogation rights, especially when it comes to complex claims or multi-party contracts?
So just sort of carries on in relation to what Patrick mentioned, Rianet, but particularly when there are multi-party contracts, I suppose from a practical perspective, an insurer would want to call for and consider all those different contracts, and consider, more importantly, I suppose, to what extent the policy makes provision for what is contained in there, specifically with regard to their potential rights of subrogation. And as Patrick mentioned, there's what they call contractual subrogation, but it's really just the parties ensuring that what terms they envisaged to be applicable, to the extent that they want to control proceedings later on, to what extent those terms are contained in the policy. I suppose from a practical perspective that one would want to clarify that upfront.
Okay.
Yes, I think Yeah, one of the leading cases in England was a good example. Before the Rugby World Cup that took place there were stadiums being built, and on the face of it, there was no subrogation right to all the contractors and subcontractors. But if you read the small print, you found that one of the contractors who did make the big mistake didn't have protection for their own negligence. So, you've got to look at things when there's multi-party, multi-complex things and a major stadium with dozens and dozens and dozens of contractors and subcontractors. So it's important to know what you're doing and read everything. It's maybe hard work, but it's going to pay off so you don't end up losing a case in the appeal court or something.
Yeah, can get very complicated. Looking across both volumes, from the technical depth of subrogation and the regulatory landscape across Africa, what do you hope the industry takes away from these resources, and how do you see them shaping better informed, more resilient insurance practices going forward? Donald.
These and the Red Book series don't equip you to tomorrow read the subrogation volume and then sign off on your doctoral thesis on subrogation. But the intention is to provide a solid foundation that gives the reader easily, accessibly, the general principles relating to the particular topic. Start there, and then either within your internal or on a sensible call, your external resources have the further discussions. There's a book on fraud in insurance, for example. If you are a claims handler or a team dealing with fraud, it's useful to have a look at that to understand the general principles and a reminder and a refresher in dealing with claims. And the same thing on subrogation, the regulatory areas, or whatever it might be. We often remind our junior lawyers, and I remind myself sometimes, is to, when dealing with a particular topic, just go back to the general principles, have a refresher on the general principles. Often one becomes confused or misremembers something that is a foundational principle that is relevant to the particular matter you're dealing with. And this is a way, without knowing that you can use this as a trusted resource, it's an easy way to go back, have a quick refresher and start from there if it doesn't give you the immediate answer. Some of them are more quirky. There's a volume, a comic book edition, where if you want to see Patrick Bracher in cartoon, you can have a look at our volume 5, for example. And there's a volume 17, Liber Rubius Magnus Collector Verborum Latinorum, which is the big red book on collection of Latin phrases. But it does have a serious purpose that if you, anyone in the industry, and you get Latin phrases constantly thrown at yourself, and we try to resist doing so, there's an easily and understandable translation of what the phrases mean. We continue. There are others that are coming on soon. So if you want to look at the spot soon, we're soon to be publishing a book on class actions. We've seen that used more frequently in the industry. Now, obviously, in preparation is our review of the 2025 insurance judgments, which will come out early in February, and there are others in progress. It's interesting just to look back, and it is useful for when I looked at it. If you see the 2018 review of judgments and the judgments now, just how the thickness of the volume has grown. And if you reflect back, there was a time where if you scan the law reports for judgments on pure insurance law, those judgments were few and far between. What is interesting now is that those are much more frequent, good or bad. And what we do in the volumes is we include only those which you think of material significance to the industry, and actually exclude probably another 10 or 20 that deal with ancillary procedural issues on insurance issues that aren't principle related. But what is significant and interesting is if you just, as a scan, do that review, you'll see how insurance is much more frequently and regularly litigated now in South Africa than it was 5-10 years ago, for example.
Wow.
Rianet, can I add to that the Red Book series is really complemented by the blog, because once you've read the book on fraud, we do is we are summarizing cases from all over the world. We look at the USA, Canada, Australia, England, South Africa, and all the recent cases, and they are there on an almost weekly basis, sometimes daily basis, so you can refresh or just see how the courts are dealing with matters. And when we started the blog, we recognized that people are busy, so that's readily accessible. I edit quite rigorously to see that the heading tells you what it's about. The first paragraph tells you what the decision was, so you can decide whether on a busy day you need it or don't need it. But it's all there, and you end up in the last line with a link to the case. And if you want to go into real detail, it's all there. So it's accessible and totally complementary to all we are writing in the Red Book.
Byron, Donald, Patrick, and Michael, thank you so much for your time. Very insightful, very technical, but I am looking forward to definitely reading more of your blogs, because I think that's where I will leave it, at the blogs. Thank you for your insights.
Thank you.
Thanks, Rianet.
Thanks very much.